employed by someone. Is it your own motorcycle? Do you know its number?
Us know the kind of particulars that we have to verify, be in position to file
Okay.
a response to this application.
Mr. Who?
Jet to Weaver's, my lord. Applicants, we are shocked but not surprised by this application for an adjournment. If this application is allowed, it will be the 10th time applicants' attempt to apply for bail has been frustrated by the DP. It will be the 10th time. So we are shocked but not surprised. 7 times before the magistrate. This will be the 3rd before you, my lord. So that will be the 10th time. 10. My lord, this application was filed on the 10th of January, fixed and served on the DPP. After frustrating the bill in the magistrate for 7 times, I can go through dates.
No.
Without going. 7 times. So record. My lord filed an affidavit in opposition sworn by Anne Kiza on the 17th of January. Nearly 2 weeks ago. It is on the court record. It filed an affidavit in opposition to the bail application. And my lord, they never raised any of what my colleague is raising. As if that was not enough, this matter was adjourned for a mention before you, my lord. And during the mention, my same colleague, not anybody else, same breath, same person, same English, never raised what they are raising. And the mention is supposed to iron out those issues. They never wrote to us a letter, kept so, never raised the mention. Because those were simple things, like, in fact, for us, the documents we have are complete. The sureties, the things she's raising, she can raise them during the trial and object to a surety. And there are many sureties. If court finds one not substantial, the other can go on. I'm saying the sureties, the point she's raising about sureties, she can raise them during the hearing, so that if court finds one of the sureties not substantial for the reason that the back page of their ID is not legible, we supply the legible part. Those are issues that she can raise during the hearing. Those are not issues that warrant an adjournment. So my lord, for them to even apply for an adjournment to file another affidavit in opposition, they would need leave.
They would need leave.
They would need leave of the court, my lord. Because when they filed this one on the 17th of January, 2 weeks ago, the pleadings were closed. What we are waiting for is a hearing. And my colleague was in court 4 or 5 days ago when this matter was adjourned. Simple letter to us, provide clear copies and copy to court, we would have provided them. This is clearly in bad faith. It's just the 10th attempt at keeping the accused in jail without a hearing of their bail application. And I invite this honorable court to reject that application for an adjournment.
Can't you propose? She has raised the problem.
Those, my lord, you see.
About the documents. The documents were few. Can you assist her with the documents?
Yes, my lord.
Right now?
Yes, my lord.
You give her.
Yes, we can give the documents. And during the hearing, because we supplied 6 sureties per applicant. So if one of them whose documents have a problem, the court can take the 2, the 3, the 4, the 5. So for me, and we can do that during the hearing. For example, the applicant A3's affidavit is the page which is, the back page is clear. A3, matter, one.
Okay, now.
So
reply to the application?
Yes, my lord, it is here.
They responded to it.
Yes, they did.
So it is supposed to come for hearing
This
today.
application, my lord, should only come for hearing, not for an addendum. I invite the court not to go back to where we have been 10 times. 10 times, my lord.
We have never filed a response to this bail application. How would we have filed a response to the bail application?
What is this document is talking about?
When we had a pending revision matter upon...
What is this document you showed?
Affidavit in opposition of bail by Anna Kiza, filed in the High Court on the 17th of January. My lord, it is 3 paragraphs. And if you look at paragraph 13, it says, I swear this affidavit in opposition.
Okay. Yeah.
My lord, I wish to clarify the purpose of that document was to guide the court not to hear any bail application until the revision matter
You read the last 2 paragraphs of that.
is handled.
My lord, the affidavit says that paragraph 12 says it is in the interest of justice that this application is dismissed.
Which application?
The bail application. It is the Republic of Uganda Criminal Division witness application number 8 of 2004, arising from that, Kakwanza Patricia, Nkwanzi Martha, Otai Charles, Amanire George versus Uganda. And then, paragraph 12, they say the application is dismissed or in the alternative not heard until the disposal of criminal division. And in paragraph 13, that is alternative, but you prayed for a dismissal of the application. Paragraph 13, I swear this affidavit in opposition to the hearing of the bail application. Then, my lord, if you look at the entire affidavit, they are saying that this application is an abuse of process and it is an application filed in opposition to the bail. My lord, it is also important, as my land friend pointed out, that the issues she is raising, we shall supply her, as court has ruled, with the original documents that she wants.
Okay, how do you want to proceed? Normally, many times, people file written what? Submissions. Written submissions?
My lord, we filed written submissions. We filed written submissions, we served the DPP. We filed this application, we served the DPP. The DPP
Yeah, so
responded.
your submissions are in writing, isn't it?
Our submissions are in writing. There is
You
no
have nothing
Yes.
to add unless you wanted to highlight something.
We want to highlight something and maybe add one point.
What about you people? Can't you respond to what? It is about responding now to submissions.
That is true, but even the submissions they are talking about, I have not received them.
Haven't you served
And
them?
I wish to be clear to court.
Mm.
My lord, the affidavit we filed that was sworn by Anna Kiza was for purposes of court not to entertain that application then on the 17th before the revision matter is handled. And court rightly guided. And then after that, when we look at the application that we were served, the documents are faint and we need to have that information verified. We are handling a serious matter which we cannot just take for granted, and we have also a right to file a proper response. We do pray, my Lord, for adjournment.
It is listed as number 008, 2024.
Is listed as number
008, 2024. And this is the application for which the state responded in opposition to bail.
yes.
And this is the application which was served on our land friends on 17th of this month.
General, okay.
Yes, my lord, there is no other bail application before you for hearing today other than this one.
Okay.
So therefore, my Lord, as you rightly intimated, we filed our submissions. And what we can do for now, my Lord, is to present our surety so that you see them. Can you file their written response tomorrow?
It shouldn't bog us down. We can do that as well. But, my Lord, I think this application should be examined in its context. By the time it was filed, we had a contestation with a pending revision application. And by the time of filing this affidavit, my Lord, it was not intended as a response, but rather as a preliminary, as a substantive response, but as a preliminary point of law to implore a court not to entertain the bail application until the revision application is determined. And indeed, my Lord, the purpose of this response was served when this court determined the revision application. Now, my Lord, upon determination of the revision application, this bail application was mentioned and eventually fixed, and hearing scheduled for today.
Yeah, this is what we know.
And indeed, my Lord, we would have been very much ready.
Okay, the point is already made.
My Lord, if I may just, if I may just summarize.
We are circling.
Yes.
So please.
My Lord, this is about an adjournment, and
you are
our
an
view.
adjournment.
Yes, my Lord. And my Lord, like my senior colleague Abel submitted, it is very unfair to expect us, first of all, to serve us with ineligible documents and expect us to be in position to answer. Because the bail guidelines as they stand today of 2022 require us to make a formal replies. Formal replies. My Lord, there is just no way, not even by way of miracle, that the DPP can be expected to make sense out of this application with documents that are ineligible. So, the only fair position, my Lord, is for our land brothers to act in good faith, give us proper documents. We do the verification as required in Rule 15 of the bail guidelines. My Lord, the import of Rule 15, we are required to verify, but we can never verify and file proper responses except if the documents are clear. So, my Lord, this application for an adjournment is in good faith. It's not intended to obstruct or delay like it is being perceived. And for us to guide this court properly, my Lord, we need proper documents and we need some bit of time to file proper responses.
I've listened.
Thank you, my
It's
Lord.
quoted Rule 15. There is no such rule. Rule 15 is about the power of this court. It says that in determining whether to grant bail or not, the court shall take into account the following factors. It lists them down. But my Lord, we take leave to hear your decision. I think continuing to have a back and
Okay,
forth
the point is simple.
No, my Lord, not submission.
What?
We want to file a formal response. We want to file a formal response, not submission. Only
Well, whatever the result.
when we have more submission
So,
and formal replies.
Can we let court hear the application?
My Lord, bail is an urgent matter.
I hear you.
My problem is that court cannot proceed to hear, except if we have responded. How? Because, my Lord, how shall we file the response after the application is heard?
My But I think an argument from the state that their response, which they filed, is insufficient, is not a ground for an adjournment.
No.
They should file sufficient responses to applications. They cannot come here with a filed response and say that their response was poor, was supposed to guide court, was intended to. That's the. They should have filed. They have had since the 10th of January. The applicants are here. The sureties are here. It would be important if we are hard.
So you filed yours, isn't it?
Yes. And my lord, we just want to supplement and introduce the sureties and bring out one particular point on mandatory bail. The accused persons have been in detention beyond the period allowed by the Constitution. So it is important, my lord, that in such a case,
Okay, you want to supplement?
Yes.
you want to supplement
Okay, hold on.
in 5 minutes.
Now, okay, gentlemen, let the. You said you want to file your response by when?
Well, we have not filed any response.
By when?
Oh,
Generally.
after they have served us with proper documents.
Okay.
To enable
You
us
served
to
them what
file.
they wanted to be served. You talked about a date. What was that one?
My lord, I had proposed that if they can file the proper documents by Friday,
What's the date on Friday
the date on Friday will be 2nd
of?
of February. We will be able to file our response to the staff.
And hold on, I know I'm not being leaning towards any side. I'm going to handle this. I have enough experience to do that. And then the applicants will file their rejoinder by when?
No, but my lord,
Because that rejoinder would include what you talked about.
before we go to the rejoinder,
Yes.
they need documents. They have asked for
Yeah, they will get them.
Friday. We can
No.
give them the documents today.
Give them today.
Yes.
All I want them is to file their response by Friday. Then your rejoinder by when? Can you do it on the same Friday? Because they should have
What
served
time
you.
on Friday, my lord?
I don't know, maybe Monday if you can't. Serve them by Friday. Put them in a court, serve them by Friday. Then if you have a rejoinder, you said some point about, what did you want?
We can, my lord, my prayer is that really for a state that has had a bail.
I don't mind. I'm now
Yes.
trying to give my position, my ruling.
My lord, may I want to pray that they file on Wednesday. I don't think it is fair for people who have been.
Unfortunately, I've already ruled on that. So when would you file your ruling?
Our
Rejoinder, yes, by.
My lord, if we are I'm sure.
They should serve you.
I'm sure they shall not serve us by morning. But if they serve, if they.
Okay, now can we go to Monday? What's the date on Monday? 5th. 5th of April. 2020. So, in the meantime, be identified. Do you have your sureties?
Yes, my lord.
You can identify the sureties.
Much obliged, my lord. We are proceeding to
My lord,
identify.
it's difficult to identify sureties before we have whose documents we even don't have. Those are the same documents.
That will give more reason to object to them. Let them bring them. But now you have a chance. Whatever, you'll raise it in your submission.
And the originals.
Yeah. So, I'm just trying to. There are so many people who keep on coming to court. So now let them be identified. In your response, you can include everything, whether they are suitable or substantial or not. So, are you ready?
Yes, my lord.
Just a minute. We need clarity because even if they are identified, will they be brought back? Because after verification, we will need more information apart from what they will provide.
Whatever
And
you,
that will be a back and forth.
whatever will be necessary will be ordered by the court. Can the sureties please come forward for identification? That is those ones who are in the application, who are included in the application.